Chapter 9. Some leading cases. It seemed convenient, in dealing with the cases mentioned in this chapter, to reproduce the material portions of the judgments as reported in the regular reports. The reader is in this way enabled to study the views of eminent judges as expressed in their own words. In Scott and Scott, the question in issue was whether, in a wife's suit for nullity of marriage, the court had jurisdiction to order a hearing in camera, and the House of Lords decided this question in the negative. The judgments of the law lords are important, irrespective of the particular point decided, in that they emphasise the great importance of publicity in the administration of justice. It is laid down that, in contests between parties, secrecy is permissible only in those exceptional cases, such as litigation in reference to a secret process where publicity would necessarily prevent justice from being done. Mere expediency is not enough to displace the principle that the courts are bound to administer justice in public. A departure from the principle is permitted only when to apply it would in effect be a denial of justice. The judgment of Lord Shaw may be thought specially worthy of consideration. He describes publicity in the administration of justice as one of the surest guarantees of our liberties, and a violation of such publicity as an attack upon the very foundations of publicity and private security, and he cites Bentham, quote, "In the darkness of secrecy, sinister interest and evil in every shape have full swing. Only in proportion as publicity has place can any of the checks applicable to judicial injustice speak. Where there is no publicity, there is no justice. Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying under trial. The security of securities is publicity." End quote, which was a series of quotes. In Local Government Board and Arlage, the Board had dismissed an appeal by Arlage against a refusal by a local authority to determine a closing order under Section 17 of the Housing, Town Planning, etc. Act 1909, and Arlage applied to the court for a writ of certiorari to bring up the order dismissing the appeal that it might be quashed on the grounds that the order did not disclose which officer of the board had decided the appeal, that the applicant had been refused an oral hearing, and that he was not permitted to see the report of the inspector who held the necessary public inquiry before the appeal was dismissed. The Court of Appeal thought that the principles of natural justice had not been observed, and made absolute a rule for a writ of certiorari. The House of Lords reversed this decision. It was laid down that, where an executive department is entrusted by Parliament with judicial duties, Parliament must, in the absence of an indication to the contrary, be taken to have intended it to follow its own procedure, and though it must act honestly and by honest means, and give to each of the parties the opportunity adequately to present the case made, it was not bound to employ the methods of a court of justice. The effect of the decision seems to be that where judicial functions are vested in a minister or government department, parties to the proceedings have none of the securities against injustice which they enjoy in judicial proceedings before the courts. In Rex and Halliday, it was held by the House of Lords, Lord Shaw of Dunfermline dissenting, that an order for the internment of a naturalised British subject of German birth, made during the Great War in pursuance of a regulation for securing the public safety and the defence of the realm under the Defence of the Realm Consolidation Act 1914, was valid. The regulation provided that, where on the recommendation of a competent naval or military authority or of an advisory committee it appeared to the Secretary of State that, for securing the public safety or the defence of the realm, it was expedient in view of the hostile origin or associations of any person that he should be subject to certain obligations and restrictions, the Secretary of State might by order require that person forthwith to be interned in such place as might be specified in the order, and might be dealt with in like manner as a prisoner of war. There was a proviso that, in the case of any person who was not an enemy subject, the order should include express provision for the due consideration by an advisory committee of any representations he might make against the order. The principal question was whether this regulation was a valid exercise by His Majesty in Council of the power to issue regulations for securing the public safety and defence of the realm, given by Section 1, Subsection 1 of the above-mentioned Act. In the Institute of Patent Agents and Lockwood, the question for decision was whether certain rules made by the Board of Trade under the Patents, Designs and Trademarks Acts 1883 and 1888 were intra or ultra vires. Section 101, subsection 3 of the Act of 1883 provided that the rules, subject to their being laid before both Houses of Parliament and being liable to annulment on a resolution of either House within 40 days after they had been laid before that House, should be of the same effect as if they were contained in the Act and should be judicially noticed. The rules in question had been duly laid before Parliament and had not been objected to within the 40 days. It was held by the House of Lords that the rules were intra vires. The importance of the case, however, lies in the fact that the law lords expressed opinions with regard to the very important question whether, in view of the provision that the rules should be of the same effect as if they were contained in the Act, it was open to the courts to canvass their validity. The point was not decided because, the rules having been held to be intra vires, it became unnecessary to give a decision upon it. The Lord Chancellor, Lord Herschel, and Lords Watson and Russell of Killowen thought that it was not competent for the courts to question the validity of the rules, but Lord Morris was of a contrary opinion. The Lord Chancellor thought that the words "shall be of the same effect as if they were contained in this Act" were really meaningless unless they meant that for all purposes of construction or obligation, or otherwise, the rules were to be treated exactly as if they were in the Act. Lord Morris thought that the only rules which were to have statutory effect were rules such as the legislature had delegated to the Board of Trade the authority of making, and that it was the duty of the court to decide whether rules which were challenged as being ultra vires were within the power delegated to the Board of Trade. In Chester and Bateson, the question was whether a certain regulation purporting to be made under Section 1 of the Defence of the Realm Consolidation Act, 1914, giving power to His Majesty in Council to issue regulations for securing the public safety and the defence of the realm, was valid. The regulation in question provided that if, as respects any area in which work on war material was being carried on, the Minister of Munitions was of opinion that the ejectment from their dwellings of workmen employed in that work was calculated to impede, delay, or restrict that work, he might by order declare the area to be a special area, and that, whilst the order remained in force, no person should, without his consent, take any proceedings for the ejectment of a tenant of any dwelling house or other premises situate in the special area, being a house or premises in which any workman so employed was living, so long as the tenant continued duly to pay the rent and observe the other conditions of the tenancy. It was declared that any person contravening the regulation should be guilty of a summary offence. It was held that the regulation was ultra vires. The prevention of the disturbance of munition workers in their dwellings was in itself reasonable, but this object could have been attained by providing that no order for ejectment should be made except under prescribed conditions. It was not a necessary nor even a reasonable way to aid in securing the public safety and the defence of the realm to deprive the king's subjects of their right of access to the courts of justice unless with the permission of a minister. R versus Home Secretary, ex parte O'Brien, was an application for a writ of habeas corpus directed to the Home Secretary. By a regulation made under the Restoration of Order in Ireland Act 1920, which empowered His Majesty in Council to issue regulations for securing the restoration of order in Ireland, it was provided that where, on the recommendation of a competent naval or military authority or of an advisory committee, it appeared to the Secretary of State that, for securing the restoration or maintenance of order in Ireland, it was expedient that a person who was suspected of acting in a manner prejudicial to that object should be subjected to restrictions, the Secretary of State might by order require that person to be interned in any place in the British Islands. On December 5, 1922, the Irish Free State Constitution Act, giving the Irish Free State a separate executive, was passed. On March 7, 1923, the Home Secretary made an order under the regulation that Mr. O'Brien, who then resided in England, should be interned in the Irish Free State in such place as might be determined by the Irish Free State Government. The Free State Government agreed with the Home Secretary that, if an advisory committee should decide that Mr. O'Brien ought not to have been deported, he must be released. It was held by the Court of Appeal that the regulation in question was impliedly repealed by the Irish Free State Constitution Act, and the order for internment was therefore illegal, and that, in view of the agreement between the Home Secretary and the Irish Free State Government, a writ of habeas corpus ought to issue addressed to the Home Secretary. Lord Justice Banks, at the conclusion of his judgment, commented on the inconvenience and dangers incident to legislation by order in council. The case is a striking example of the application of the rule of law in aid of the liberty of the subject. In R versus Electricity Commissioners, the Commissioners had formulated a scheme for the improvement of the organisation for the supply of electricity in a certain district, in purported exercise of their powers under Sections 5 and 6 of the Electricity (Supply) Act 1919, and were proceeding to hold a local inquiry on the scheme as required by the Act. By Section 7, subsection 1 of the Act, the Commissioners may make an order giving effect to a scheme embodying decisions arrived at as the result of the local inquiry, and present the order for confirmation by the Minister of Transport, who may confirm it with or without modification as he thinks fit. And by Section 7, subsection 2, any order so confirmed is to be laid before Parliament, and is not to come into operation until it has been approved, with or without modification, by a resolution passed by each House, and when so approved it shall have effect as if enacted in this Act. On an application for writs of prohibition and certiorari, it was held by the Court of Appeal that, the scheme being ultra vires, a writ of prohibition should issue, prohibiting the Commissioners from proceeding further with the consideration of the scheme. The case is important as showing that the court is not precluded by this form of legislation from intervening if the government department exceeds the limits of its authority. Lord Justice Younger, as he then was, seemed to be of opinion that, even if an order had been confirmed by the Minister of Transport and approved by resolution of both Houses, it would still have been open to the court to inquire whether the scheme was one which under the Act the Commissioners had power to formulate, and if not, to quash the order as ultra vires. This view is in accordance with the dissenting view of Lord Morris in the Institute of Patent Agents and Lockwood. In the Board of Education and Rice, the board had purported to decide certain questions submitted to them for decision under Section 7, subsection 3 of the Education Act 1902. It was laid down that in deciding such questions the board were in the nature of an arbitral tribunal from whose determination in law or fact there was no appeal to a court of law, provided that they acted in good faith and fairly listened to both sides. But as the board had not in the particular case determined the questions submitted to them, it was held that the purported decision must be brought up by certiorari and quashed, and that a writ of mandamus must issue commanding the board to determine the questions. Scott and Scott, L.R. 1913, Appeal Cases 417. A wife's suit for nullity of marriage on the ground of her husband's impotence was ordered by the Probate, Divorce and Admiralty Division to be heard in camera, and the petitioner, after a decree nisi had been pronounced, published to certain persons copies of the shorthand writer's notes of the proceedings. This publication having been held to be a contempt of court, it was decided, on an appeal to the House of Lords, that the court had no jurisdiction to make the order for a hearing in camera. Page 437, the Lord Chancellor, Viscount Haldane, quote, "While the broad principle is that the courts of this country must, as between parties, administer justice in public, this principle is subject to apparent exceptions, but the exceptions are themselves the outcome of a yet more fundamental principle that the chief object of courts of justice must be to secure that justice is done. In the two cases of wards of courts and of lunatics, the court is really sitting primarily to guard the interests of the ward or the lunatic. Its jurisdiction is in this respect parental and administrative, and the disposal of controverted questions is an incident only in the jurisdiction. It may often be necessary, in order to attain its primary object, that the court should exclude the public. The broad principle which ordinarily governs it therefore yields to the paramount duty, which is the care of the ward or the lunatic. The other case referred to, that of litigation as to secret process, where the effect of publicity would be to destroy the subject matter, illustrates a class which stands on a different footing. There it may well be that justice could not be done at all if it had to be done in public. As the paramount object must always be to do justice, the general rule as to publicity, after all only the means to an end, must accordingly yield. But the burden lies on those seeking to displace, page 438, its application in the particular case to make out that the ordinary rule must as of necessity be superseded by this paramount consideration. The question is by no means one which, consistently with the spirit of our jurisprudence, can be dealt with by the judge as resting in his mere discretion as to what is expedient. The latter must treat it as one of principle, and as turning, not on convenience, but on necessity. Unless it be strictly necessary for the attainment of justice, there can be no power in the court to hear in camera either a matrimonial cause or any other where there is a contest between parties. He who maintains that by no other means than by such a hearing can justice be done may apply for an unusual procedure, but he must make out his case strictly and bring it up to the standard which the underlying principle requires. He must satisfy the court that by nothing short of the exclusion of the public can justice be done. Page 440, Earl of Halsbury. I am of opinion that every court of justice is open to every subject of the king. I will deal presently with what have been called exceptions to that rule, though I think it is a mistake as to some of the so-called exceptions thus to describe them, but I want in the first instance to emphasize the broad rule I believe to be the law. I believe this has been the rule, at all events, for some centuries, but as I will attempt to show presently, it has been the unquestioned rule since 1857, unquestioned by anything that I can recognize as an authority. Page 441. There are three different exceptions, commonly so called, though in my judgment two of them are no exceptions at all. The first is wardship and the relation between guardian and ward, and the second is the care and treatment of lunatics. My lords, neither of these, for a reason that hardly, page 442, requires to be stated, forms part of the public administration of justice at all. Again, the acceptance of the aid of a judge as arbitrator to deal with private family disputes has, by the express nature of it, no relation to the public administration of justice. My lords, while I agree with the Lord Chancellor in the result which he has arrived at in this case, and generally in the principles he has laid down, I wish to guard myself against the proposition that a judge may bring a case within the category of enforced secrecy, because he thinks that justice cannot be done unless it is heard in secret. I do not deny it, because it is impossible to prove what cases might or might not be brought within that category, but I should require to have brought before me the concrete case before I could express an opinion upon it." End quote.